Hey everybody, Brett Thompson again. It's Tuesday, so you know what that means. Another installment of our Teaching Tuesday. So I had some calls from some real estate agents, and they would like to see a video pertaining to required disclosures for real estate agents. There is one statutory disclosure that I want to cover today. So it's the disclosure of an agent's ownership interest in real estate that they are either purchasing or selling. So a salesperson and a broker, and this is pertaining to Virginia law. So a salesperson is commonly known as a real estate agent. Section 54.1-2138.2 is the duty to disclose ownership interest in specific real property. I'm going to paraphrase the statute. A licensee that knows or should know that he, any member of his family, his firm, any member of the firm, or any entity in which he has an ownership interest is acquiring or selling. He has to disclose that in writing that he has or will have an ownership interest in the property. So the real estate agent could be a member of an LLC, and let's say the LLC owns a piece of real estate and the LLC is selling the real estate. So if that agent involved in that transaction is a member of that LLC, that agent in writing on the contract would have to disclose that, hey, I'm a salesperson licensed in the Commonwealth of Virginia that has an interest in this real property through my membership in the LLC. If the LLC is purchasing a piece of real estate, same disclosure, right? Because so that real estate agent that is involved in the transaction is a member of the LLC, and the member of that LLC will acquire an ownership interest in the property. So in a nutshell, if you are an agent, a broker, a licensed salesperson in the Commonwealth of Virginia, and you are involved in the transaction in which you, a family member, an affiliate entity, either owns it or will have ownership interest upon this, the purchase of it, that has to be disclosed in writing. Now, salespersons, brokers, they can also be a realtor, okay? So a realtor and a salesperson they're two different things, meaning that a salesperson can be a realtor. A realtor means that you are a part of a particular club and you're part of the National Association of Realtors. And here in Hampton Roads, there's a local division called the Hampton Roads Realtors Association. So if you're a member of this particular club or association, they have their own code of ethics that they must adhere to. And if a realtor is in violation of the code of ethics, there are certain disciplinary actions that can be made that are done internally throughout the Realtor Association. I did take a look at the Realtor Code of Ethics, and that language is a little broader. So it talks about a realtor's interest in property, either directly or indirectly, but it also says in selling property, they own or in which they have any interest, realtors shall reveal their ownership or interest in writing to the purchaser or purchaser's representatives. So that goes a little bit further. That language is a little broader than ownership interest. And one thing that I could use as an illustration would be, it's not uncommon for a salesperson, okay, a real estate agent or a realtor, regardless of whichever you are, to maybe you'll front the money. Let's say you're representing a seller and you're going to put up the money to stage the home with furniture. All right. Maybe the home needs some improvements. Your seller doesn't have the money to make the improvements. So you put up 10 grand, 15 grand, pay contractors to do various improvements on the property. Now, that alone does not create an interest in the property. You would have an interest to get paid for your services rendered by your seller. However, if you secured this money, let's say you treat it as a loan and you had your seller sign a promissory note and you also recorded what's called a deed of trust, which actually places a lien on the property and turns the house into the collateral for this loan. So let's say you fronted 20 grand to your seller and you're a realtor and you had your seller sign a promissory note and you also recorded a lien in the land records, such as a deed of trust. Well, under the broad language of Article 4 of the Realtor Code of Ethics, you would have to disclose that you do have an interest in the property. In that particular situation, you would have an interest as a lien holder. You wouldn't own the property, but you would have an interest as a lien holder, as you have a recorded lien in the land records. So I wanted to kind of like make a little distinguishing example. Outside of that, okay, there isn't a duty to disclose. So if you do front some money to stage the home, or you even front some money to do some improvements to a home, you don't have an ownership interest, so you would not have a duty to disclose under Virginia law. I don't believe that you would have a duty to disclose under the Realtor Ethics Code. However, if you then secured your interest as a lien holder, then I think that you would have to disclose the fact that you have an interest as a lien holder in the property. So I hope that is helpful, gang. Real estate agents, realtors out there, if you got any follow-up questions, feel free to reach out. Thanks a lot.